I think we shall begin.
Yeah.
So, good morning, good afternoon, good evening, depending on where you are. Welcome to this African Development Bank and African Legal Support Facility joint webinar on the role of legal support in effective debt management. This webinar is part of a debt management series that is being put together and provided with support from the government of Japan's Fund for African Private Sector Assistance. My name is Nicole Kiers, and I'm Senior Legal Counsel at the African Legal Support Facility, where I also head the sovereign finance sector. I'm going to be your moderator for today's very important and hopefully interesting and engaging discussions. Today's webinar will look at the role of legal support in effective debt management through several lenses, and will explore restructuring processes for sovereign borrowers, including the various relevant processes and procedures, as well as recent challenges and opportunities. We'll also have a look at proposed modifications to the contractual framework within the sovereign debt restructuring architecture to see what changes may be made to debt documentation to improve restructuring processes and to build resiliency. We'll also have a quick-ish look at the role of the importance rather of legal support to ensuring effective debt management, and focus a little bit more on the work that the African Legal Support Facility does in this area to support African governments with debt management. In terms of today's agenda, we'll start with introductory remarks from both Tataki Nomoto, who's the Executive Director at the African Development Bank, and Olivier Pognon, who is the Director and CEO of the African Legal Support Facility. We will then have a presentation from my colleague, Laria Aranitoy, who is legal counsel, heads the energy portfolio, and also has extensive experience in sovereign debt matters on the continent. Following the presentation, I will introduce our panel of esteemed speakers who will do a deeper dive into the subject, focusing on practical examples based on their own experiences. The panel will be followed by a Q&A session where you'll have the opportunity to ask any and all questions that you have regarding either what's been discussed or other issues that you're thinking about related to the subject matter at hand. Finally, we will have concluding remarks from Director Coulibaly Abdullahi, who is the head of Governance and Financial Management Department in the Economics and Knowledge Management Vice Presidency of the bank. I trust everyone will enjoy and learn a lot from today's webinar. Our first speaker, Mr. Tataki Nomoto, has been acting as Executive Director representing Argentina, Australia, Brazil, Japan, and Saudi Arabia since 2021. Prior to this role, he was Senior Advisor to the Executive Director for Japan within the World Bank Group. He has also served as an economist at the Asian Development Bank and worked in the Japanese government's Ministry of Finance. Welcome, Mr. Nomoto.
Thanks, Nicole, for the floor. And firstly, so good morning and good afternoon, good evening. So I'm very honored to be invited to this seminar and to provide opening remarks. So here, firstly, let me say thanks to Dr. Olivier Pognon and also Dr. Abdullahi and the offshore African governments and the distinguished speakers and commentators, colleagues, and ladies and gentlemen. Thanks very much for this opportunity, also attending this seminar. So here, I also congratulate on this successful organization of this fourth round debt managing webinar series. And the debt management issue is, of course, one of the priorities for Japanese government, and we have been supporting this webinar series from the very beginning. And I'm pleased to participate in today's seminar on behalf of Japan. And also the debt issues were emerging even before actually COVID-19 in some African countries. And then after the COVID-19 occurred in 2022, we have been witnessing a difficulty for the most African countries. And then in February 2022, we see the issues in Europe, and that added further difficulty to Africa through food and energy prices. So now the IMF Debt Sustainability Report identifies the 19 countries, 19 African countries are either at high risk of debt distress or already in debt distress, while only 8 was identified in 2019. So, and then on this one, G20 have initiated the common framework for debt treatment beyond the DSSY. And currently 3 countries are under this common framework. And then as we know, this process is a little bit slow, rather than expected, but we have seen a significant advancement in Zambia's case during the last month's summit for New Global Financing Pact in Paris. And then in the last seminar, actually, we have been discussing this common framework issue a lot. And then I hope that that was also providing a new learning. And then I hope that today's webinar will also take us to a new learning. Today is on the role of legal support in effective debt management. While the external debt from the MDBs or bilateral governance, so-called traditional donors, was decreased, but as many recognize that debt from non-traditional donors or like commercial traditional lenders has increased dramatically. And so this is a kind of new characteristic of the African debt. And in this context, the legal aspect of debt management becomes hugely important. And here I want to emphasize that getting the learning from the current problem are very crucial to prevent the future problem. So like when I visit some African countries, they are now trying to contract on, say, like exploring the new natural resources from now with global companies. So on this one, even on this one, I think we can get a kind of new learning from this seminar. And then I hope that the lessons are well disseminated with them and ALSF, FDB, and other MDBs, and other traditional donors, and all the relevant stakeholders. So finally, using this opportunity, I want to commend the ALSF's vital role in this area, and I hope to see the continuous activity and capacity strengthening of African government in this field. At the same time, I would also like to thank the FDB's governance and economic reform department for this extraordinary efforts in this area. In addition, I also appreciate PAPA colleagues supporting this. It's a Japan's Trust Fund in FDB. So finally, I appreciate very active participation by all audiences today. I wish all participants excellent deliberation. Thank you very much for this opportunity.
Thank you very much for those remarks, Mr. Maruto. So I'll now pass to our next speaker, who is Olivier Pognon. He is the director and CEO at the African Legal Support Facility. Prior to joining us at the ALSF, he was Chief Legal Officer of Airtel Africa, and before that, he was Senior Counsel for the NTM Group. He also has extensive experience that he gained from working at Agence Française de Développement, EY Law, and other large international law firms. So over to you, Mr. Pognon. Thank you.
Thank you. Thank you, Nicole. Thank you, Dr. Nomoto, for your introductory words. Good afternoon, everyone, and thank you for joining this conversation. Let me just start by thanking our colleagues from the bank, ICGF, for their partnership in implementing this series of webinars, and of course our partners, PAPA, for their keen support with this initiative. We're having this conversation in a context, as Dr. Nomoto mentioned, in a context of worrisome debt crisis facing a number of our regional member countries. The factors of the debt stock growing over the past 10 years are known, and maybe we shouldn't dwell on them too much, but there are change in the debt structure. COVID came, then strong inflation ensued. War in Ukraine came to on top of everything. So we know where we are in terms of the debt situation of our countries. But we also know, and we also witness some changes in certain patterns that we've seen in the past. Countries are challenging some assumptions, and there are calls for reform of the debt sustainability framework that sort of always framed the borrowing patterns of our countries. Countries are also challenging traditional approaches. For instance, debt cancellation is no longer seen as a cure-all and a must-have. And then one other example is that there's questioning, if not rejection, of asset-backed borrowing, and we heard strong words from Dr. President Adesina in the past few months, regarding asset-backed loans and the very unjust kind of attributes. So it is with this background that we seek to understand how sound legal support can help our member countries manage their sovereign debt in an effective and sustainable manner. And this is based on the very relevant presumption that, number one, the rule of law and contractual balance should prevail in any transaction, particularly the ones that involve public wealth. And another spot-on presumption is that debt is a very technical and very complex subject. And we all know this say that as long as the lion can't write, the hunter will keep telling his side of the story. So we're at a stage where African countries need to start deliberately writing their side of the story when it comes to debt management. Well, the good news is that someone is very committed and very able to consider that question seriously and address it by all means necessary. That someone is the African Legal Support Facility. Since roughly 2017, 2018, we have gradually built and developed an expertise in sovereign finance. We've assisted some of our regional member countries with advisory services, and we also provide capacity building as we speak to a number of our countries. So we are well placed, therefore, to play a role as trusted legal advisor of African governments with respect to their debt management strategy and associated legal requirements. I think this conversation will further illustrate how we intend to do that and how we can possibly do that with the support of other colleagues. One is to support debt management offices with capacity building. Second is to help them with a debt management strategy, whether it's debt cancellation or debt restructuring or new instruments, climate related or blue finance. Those new instruments that countries are trying to start implementing must be those implementation must be done in a fully informed manner from a legal standpoint. One thing that I would like to strongly insist on is that African countries need to start using all negotiating power available to them, because the geopolitical landscape is changing. Debt management strategies are being affirmed. People are getting more and more informed and trained when it comes to debt management. So there's a negotiating power that comes with that that needs to be exploited. And finally, as in incident intervention, we assist sovereign wealth funds with their legal restructuring and with advisory services to help them generate domestic revenue, that will alleviate the debt burden. So again, thank you all for making time. I hope there will be lots of learnings and discussions around effective implementation arising from this conversation for the benefit of our country, and such that as Lions we can start writing our story. Thank you all.
Thank you very much, Olivier, for your introductory remarks. I'm now going to invite my colleague Laria, who's going to speak to us about debt restructuring and the contractual framework that underpins effective debt management. So I'm just going to pull up her slides. Laria, over to you.
Thank you, Nicole. Good morning and good afternoon. As introduced by Nicole, the topic of this presentation is debt restructuring and the contractual framework underpinning effective debt management. This presentation will cover the legal framework of sovereign debt, the initiatives that have been developed to improve the contractual framework within the sovereign debt architecture, and the value of legal advisory to African sovereign debt managers. Unlike for corporate borrowers, there is no formal bankruptcy regime for sovereigns that are not able to pay their debt. Instead, there are processes and frameworks that have been developed to govern sovereign debt restructuring. And these are restructuring of debt under the IMF framework, the Paris Club restructuring, restructuring of debt through the G20 Common Framework, and ad hoc restructurings. I'll briefly describe these processes and how they work. The first process is the restructuring of debt under the IMF framework. In cases where a member of the IMF faces solvency or liquidity problems, they might require to restructure their debt to restore sustainability. In such instances, the sovereign can use the established IMF framework to assess its level of liquidity and either reschedule its maturing obligations if the problem is one of liquidity, or obtain a reduction in debt service if it is a solvency problem. Because the fund will seek assurances that the restructuring will return the sovereign to sustainability and that that restructuring process will attract sufficient creditor participation, the program tailored for the sovereign typically incorporates structure adjustment requirements. Worth noting is that the fund supports both preemptive debt restructuring and post-distress relief. The second process is the Paris Club restructuring. The Paris Club is the main institutional framework for restructuring of external bilateral debt. The Paris Club is an informal group of bilateral creditors. Its membership comprises of governments of 22 of the world's largest economies. But the club periodically invites creditor governments to participate in its restructuring process. It's important to note that the Paris Club has no legal status or statutory rules, but follows a set of established negotiation rules. And how does a country access the Paris Club? A country that wishes to restructure its bilateral debt approaches the club secretariat, and it is required to prove or commit to some conditionalities before its restructuring application is permitted. And key of these conditionalities are that the sovereign is indeed unable to meet its maturing obligations, that it is committed to seek comparability of treatment from private creditors and other non-Paris Club bilateral creditors, and that it has submitted to an IMF program. The outcome of the Paris Club negotiations are non-binding. But what they do is they establish a minimum relief conditions that then guide the negotiations of actually binding agreements amongst the bilaterals and the sovereign. The Paris Club has successfully negotiated over 400 restructuring agreements, and it continues to be the preferred framework for restructuring of bilateral debt. So moving on to the common framework, the long form or the long reference of the common framework is actually the Common Framework for Debt Treatment Beyond the G20 Debt Service Suspension Initiative, or the DSSI. It's a mouthful. But what it means is that it is G20's replacement for the DSSI. Some of you will know that the DSSI was G20's assistance to low-income countries in response to the COVID-19 pandemic, global-induced recession. The DSSI expired in 2021 with close to 13 billion in debt service suspension, and following of which the G20 found it appropriate to initiate the common framework. However, unlike the DSSI, the common framework provides actual debt relief options to 73 of the DSSI eligible countries. Debt treatment is based on an IMF program, and the debt agreements that arise out of the framework are again non-binding, but they set a minimum relief of conditions with which subsequent binding agreements are entered into. Despite the fact that 73 countries are eligible, only 4 countries have sought relief under this framework, and these are Chad, Ethiopia, Zambia, and Ghana. There's been some loud criticism about the effectiveness of the common framework. However, Zambia did reach a debt agreement treatment in June 2023, and this milestone seems to have spurred a bit of optimism about the framework. So the above 3 frameworks are not mandatory. A sovereign can elect to structure its debt using any procedures outside of these frameworks. And when this is done, that is referred to as an ad hoc debt restructuring. Slide, please. So now that we've discussed, at least we've touched on the debt restructuring frameworks, we're going to delve a bit into the contractual interventions that have been put in place in order to respond to collective action problems and also to ensure sustainability. Globally, it is evident that the tried and tested sovereign finance structure has been challenged by the change in diversity of the creditor landscape. There's been increment in the bilateral and private credit, and a key challenge that has been impacted by this change is the concept of collective action problems. This section of the presentation looks at the initiatives that have been developed to improve the contractual framework within the sovereign debt architecture in response to collective action problems and sustainability concerns. The first concept that will be discussed is the concept of collective action problems. Collective action clauses. Collective action clauses enable a specific majority of bondholders to bind all the bondholders in the same issue on financial terms of restructuring. And by enabling the majority to bind a dissenting minority, these collective action clauses are important because they address collective action problems and facilitate an orderly restructuring. The International Capital Markets Association enhanced the CAC regime in 2014 by providing a detailed standard option and method of implementation for use of the CACs in sovereign bond issuance. And this enhancement has spurred the use of collective actions broadly. And to date, collective action clauses are actually found in most sovereign bonds. The next advancement in the contractual framework that has been instrumental in structuring processes is the majority voting provisions. Majority voting provisions are most relevant in syndicated lending. Previously, any amendment of payment terms of a syndicate required unanimous agreement from all the syndicated members. What this majority voting majority voting provisions do is that they allow specified majority of syndicate members to bind all the members of the syndicate on an amendment of payment terms. And this could be either a scheduling of maturity of debt or even reduction of principal debt. The flexibility provided by these majority voting provisions is intended to ease the participation of the syndicated lenders in sovereign restructurings. At the end of last year, ICMA, based on internationally recognized corporate loan agreements, to formulate specimen clauses and publish guidance notes, and these are a very useful resource on majority voting provisions that we urge you to look into. Another development worth discussing is the clarity that has been provided on the pari passu clause. The standard pari passu clause in sovereign loan agreements prevents a lender from being subordinated to other unsecured or unsubordinated lenders. The standard pari passu clause had various interpretations in the market, and because of that, it was widely debated upon and was subject of various court cases. One of the most controversial cases on the interpretation of the standard pari passu clause was a case against Argentina, in which a New York court held that the manner in which the Argentina pari passu clause had been drafted actually prohibited Argentina from paying participating bondholders of a restructuring process without paying the holdout bondholders. This judgment was controversial because it posed the risk of giving individual sovereign creditors a veto right during the restructuring negotiations. And because of that, it was widely advocated that there was need for clarity on whether the standard pari passu clause provided for equality of legal ranking only, or whether it provided for both equality of legal ranking of debt and equality of payment. This clarity had been incorporated prior in the standard bond documents, but had not been incorporated in sovereign loan agreements. And so when the International Capital Markets Association provided clarification that the standard pari passu clause actually provides for equality for ranking of debt and not for the ranking of payment, it was welcomed as an initiative that has the potential to address holdout creditor risk. Slide, please. Another development in the contractual framework that has been predicted to have significant relevance to the continent is the concept of state contingent debt instruments. SCDIs, as they are commonly referred to, are debt obligations in which a sovereign promises to pay a return whose value is dependent on a variable reference. For example, where the variable reference is the sovereign's GDP, how it will be implemented is that if a sovereign's GDP increases, then the sovereign's obligation, the sovereign's obligation return, the amount of return that the sovereign has got to pay increases. And where the sovereign's GDP goes low, then the sovereign will be required to pay a lower return. Examples of state contingent debt instruments include inflation-linked bonds, such as the one that was issued by South Africa, performance-linked warranties, value recovery instruments, which are typically based on commodity prices, climate resilient debt clauses, which we'll go into in detail later on, and pandemic debt suspension clauses. The attraction of state contingent debt instruments for the continent is that they link debt capacity to repayment obligations. And why is this important? It's perceived to be a better risk allocation for the continent because since the continent is comprised of volatile economies and volatile commodity prices. So the idea that the requirement to pay is dependent on whether the country has the capacity to pay is found to be attractive based on the volatility of our economies. However, despite the fact that they've been widely praised, they have not yet to be widely adopted. And this could possibly be due to the difficulties that have arisen in actually restructuring, in the structuring of these instruments, and also the complexity of fixing their prices. That said, they're definitely an instrument to keep a keen eye on. I'm going to dig a little deeper into two of the examples of the state contingent debt instruments as they relate to occurrences that have or could greatly impact the continent. The first example is the climate resilient debt clauses. These are contractual provisions in debt instruments that provide baked-in relief for climate-related shocks that lead to financial loss. They allow a borrower to suspend or even lower their principal debt following the occurrence of a predetermined and agreed climate shock or natural disaster. The moral justification for these clauses is that they provide the sovereign borrower with breathing room and enable the sovereign to rechannel their limited resources to disaster responses. They may even preempt costly and complicated restructuring by enabling the borrower to pay when they are in position to do so. It's important to note that climate resilient debt clauses are not, they don't reduce the amount of debt payment required, but rather they suspend debt payments until the sovereign is in position to pay the debt, to repay the debt. In order for CRDC to be effective, there is need to clearly define a trigger event. And a trigger event is an event that either allows the borrower to suspend its debt or to request for suspension of debt. By way of example, in Grenada, in a Grenada restricted bond, a trigger event was linked to a payout by an insurance facility related to a tropical cyclone. What that meant is that Grenada, as a country, was allowed to initiate debt suspension discussions once the insurance facility had made a payout in relation to a tropical cyclone insured event. The use of CRDCs are on the rise. And for example, in Barbados, following their restructuring in 2019, all the country's subsequent bonds contain CRDCs. We've also seen multilaterals like the UK Export Finance starting to add CRDCs in their lending documentation. Another example of a state contingent debt instrument that is worthy of further discussion is the pandemic debt suspension clauses. And these are one of the latest financial interventions at improving debt resilience of sovereigns. They allow borrowers to temporarily suspend debt repayment when a pandemic occurs. And they've been referred to as baked-in DSSIs relating to the G20 debt service suspension initiatives. Again, like CRDCs, they enable the country, they provide the country with some relief and enable the country to focus its limited resources on pandemic responses. In 2020, Barbados was the first country to issue a pandemic-protected bond, but we hope to see more of them in the future. For these resilience clauses, it's important to note that scale is important for them to be impactful. They must be negotiated into a significant number of the borrower's debt instruments for the borrower to obtain worthwhile relief. It's also important to note that these interventions are not catch-all solutions, but they are definitely a good step in the right direction. And now that we've set the pace now that we've set the scene for restructuring of debt and the recent topical contractual amendments to the debt framework, why is legal support important? Why should a debt manager seek external legal advisory? The reality is that debt restructuring is complex. The above presentation has attempted to simplify these interventions the interventions that have been made to introduce resiliency and address holdout creditor risk, but the actual structuring and drafting of these provisions is fairly complex. Because of this complexity, debt officers require legal practitioners with best-in-class competence and vast experience to assist them to navigate the murky waters of legal and regulatory risks and political litigation outcomes. It also cannot be understated that once debt managers agree to less than optimal borrowing terms, they increase the pressure on other public borrowers to replicate these terms in subsequent loan agreements. And therefore, it is extremely important to get the initial precedents right. Even though debt distress is not a topic of this webinar, legal advisory is also critical in debt distress scenarios. And legal practitioners can provide a wide range of valuable services. And some of these services in debt distress scenarios include assisting in the analysis of legal risk and formulation of a legal strategy, working with the financial advisors to formulate a coordinated strategy of engaging the creditors, assisting in defining the parameter of debt in a manner that maximizes debt relief and ensures intercreditor equity, assessing how effectively to secure sovereign's priority assets, and ensuring that any media strategy that has been formulated does not expose the sovereign to additional legal risk. A director has eloquently articulated the role of legal support, the role of the ALSF in effective debt management. But I'll just reiterate that the facility's mandate is to provide legal advice and technical assistance to African governments in the negotiation of complex commercial transactions. And it's on that premise that we do have the capacity to assist African governments to effectively manage their debt. We do have a sovereign finance sector whose offering covers the entire evolution of sovereign debt, from assisting with new issuances to restructuring of sovereign debt and everything in between. And just to add on what the director said, some of the offerings include conducting debt stock analysis and debt service analysis, restructuring and managing of sovereign wealth funds, providing general creditor litigation and litigation risk assessment support, restructuring domestic commercial debt, and defending claims brought against voucher funds. We're happy to engage with you separately on any of our offerings. I thank you for listening.
Thank you, Laria, for that very enlightening and interesting presentation. Before we move on to the panel discussion, I just wanted to summarize some of your key points. First, and very importantly, there's no formal bankruptcy regime for sovereign borrowers. As a result of this, and given the complexities around sovereign borrowing, the framework for sovereign debt restructuring draws upon several disciplines and various national and international legal regimes. The other point that you made that was really important was about innovations to the contractual framework within the sovereign debt restructuring architectures, and that these have been done in order to try to improve resiliency and to reduce more generally creditor risk, in particular related to holdout creditors, excuse me. Another thing that you talked about is the importance of engaging legal counsel in order to ensure optimal results for sovereign borrowers. And this should be done early and as quickly as possible, so to ensure the best outcomes for the sovereign borrowers on a long-term basis. Finally, picking up again on what Olivier said earlier, you did mention the importance of the ALSF and the ways in which we support governments in achieving the goals that we've been discussing today. So for our next discussion, we will continue the conversation about Africa's sovereign debt, looking a bit more deeply and further into the legal and contractual frameworks that support and enhance effective debt management. We will also do a deep dive into Africa's experience with debt restructuring, including current challenges and, of course, areas of improvement. So we'll ask our panelists to kind of tease those answers out as they go along. So before we dig in, I want to introduce our wonderful panelists, starting with Dr. Kevin Lumbila. He is the acting head of division for the Governance and Economic Reforms Department at the African Development Bank, where he is responsible for the Central, North, and West African regions. Mr. Lumbila has experience in various areas, including public policy, public sector management reform, debt, of course, public expenditure and tax administration reforms, growth strategies, development finance, and portfolio management. At the bank, he has also served as senior expert and chief expert in the governance office and as governance portfolio coordinator in the Central African region. Prior to joining the African Development Bank, he worked as an economist at the World Bank. Next in line, and I'm going alphabetically, is Dr. Magali Masamba. She is a law and policy advisor who currently holds the title of Extraordinary Lecturer at the Center for Human Rights at the University of Pretoria. She is also a senior fellow at the African Debt Justice Network. Dr. Masamba advises on global economic governance, sovereign debt, climate finance, and other aspects of development finance, and has advised African governments and multilateral governments, organizations rather, NGOs in these kind of matters. Next, we have Ms. Meluleki Simbanda. Ms. Simbanda is Deputy Legal Advisor at Zimbabwe's Ministry of Finance and Economic Development, where she is responsible for providing legal advisory services to the ministry departments, parastatals, and to Treasury. Within the Public Debt Management Office, she has contributed to the drafting and negotiation of various debt instruments, as well as participated in debt restructuring negotiations. So her expertise will be very key to today's discussion. She also has vast experience in negotiating investment agreements, as well as related legislative drafting. Last, and of course not least, is Professor Rodrigo Oliveres Caminal. He is a professor in banking and finance law at the Center for Commercial Law Studies at Queen Mary University of London. He's also of counsel at Kepler Kars Law Firm, where he advises clients, including sovereigns, in an array of financing, restructuring, and insolvency matters. Professor Oliveres Caminal has worked extensively with the ALSF, in particular with helping us to develop various knowledge products. So for example, he is the brain behind the ALSF sovereign debt capacity building training and the corresponding handbook. He's also one of the wonderful authors that we had working on our handbook, which is called Understanding Sovereign Debt, Options and Opportunities for Africa. So welcome everyone to this panel discussion. I think we'll keep it hopefully light and interesting feel free to ask or, piggyback on other people's responses as you go along. The first question that I have is going to be directed to Mr. Lumbila. Mr. Lumbila, how significant is the issue of inadequate legal frameworks for debt management in Africa? And in answering that, if you can express to us how that manifests specifically, that would be great. Thank you.
Thank you, Nicole. Thank you. Good evening, good morning, good afternoon, colleague. All the regard to Edie Namamoto. Thank you for this event and the opportunity to contribute to the question on inadequate legal framework. I would like to say this. The issue on the legal framework for debt is about comprehensiveness. The first issue that I see, ideally, public debt management legal framework should be comprehensive and include the mandate to borrow, to issue guarantee, establish the authority to conduct day-to-day debt management, that DMOs in general, determine the role and responsibility to various players, close to cover the issue of reporting, transparency, and so on, outline borrowing restrictions such as the scope of debt, the purpose of borrowing, debt ceiling, etc. The good thing as our country are concerned is that in many countries, public debt management legal framework are already anchored in the constitution, where broad principles are laid out and specific provisions are prescribed in national, primary, and secondary law. However, in practice, since as we can witness, the debt landscape evolve so rapidly with the ever-changing economic and financial context, some countries are yet to align with the international best practice. So we can see some gap. The first one that I can mention is scope. When the scope of debt is not clearly and comprehensively defined. In that situation, we find countries likely to have issue in managing the public debt, as there is no guidance on what constitutes public debt. In addition, the issue of contingent liability that is not always well captured can happen here. If that issue is not properly managed, we find easily that the debt can be inflated suddenly and push to a sustainable level if the risk event crystallize. So defining the purpose of borrowing always protect against borrowing for unproductive project or the purpose that are not aligned with government priority. There is another issue in terms of gap that we are about this inadequacy of debt is some legal framework do not define the purpose of borrowing. And that is a really a problem. A good legal framework should restrict government borrowing so that it serves a certain purpose. So there should be some guidance in terms of what is the purpose to borrow. And also in a proper legal framework, we should know who has the authority to contract debt and can exercise that power on behalf of the government. Usually is the Minister of Finance, but it's very good in the legal framework that is comprehensive that the role of Parliament, the Cabinet, and other ministries than the Minister of Finance, sometimes Minister of Planning, Cooperation, and Line Ministry can be involved in debt contracting. And another gap is, I would say, at the level of debt limit in some legal framework and the financial term. Well, these are not existing. That's also a problem in terms of comprehensiveness of debt. The second issue I see on the inadequacy of legal framework is the lack of weak compliance with international best practice or on domestic law and the regulatory framework. So we found some country, they cannot either observe best international practice or even not be able to comply to their own, I would say, legal framework. That's pose a problem of inadequacy of framework. This is the situation, for example, for Mozambique, where public debt was contracted outside the authority of the law. Several African states have not been able to comply with debt limit they agree to. For example, within the IMF program, that's an issue. In most cases, the public debt exceeded the limit or increased the limit for external borrowing several times to be able to accommodate more borrowing. That was the case of Zambia and Kenya. Therefore, this country went beyond the convergence threshold of the regional blocks and accumulated debt and sustainable level. The third point I would like to make about adequacy of legal framework is the role that is supposed to play the oversight body here, the parliament in the legal framework. And that role, we noticed that through country is not homogeneous, and in some countries we can find parliament will approve all public borrowing. In other countries, parliament does not approve individual loan, but instead approve the state borrowing strategy or plan in the context of budget. In a few countries, parliament approve is not mandatory. Loans are disclosed to parliament for information after the loan agreement have been signed. It's important that the legal framework reinforce the role of parliament to provide the required guidance and protection and transparency. The fourth and I think the last issue I mentioned here about inadequacy in legal framework in public debt management is the fragmentation, the institutional fragmentation that we have noticed almost in every country. The legal framework is dispersed across different institutions. The Minister of Finance can usually delegate some of its authority on behalf of the government to other institutions, such as the central bank, to undertake domestic borrowing. In some countries, you can find, as I mentioned before, Minister of Planning, Cooperation, Foreign Affairs, even central bank can engage directly in debt contracting with donor and partner in the usual interaction. So in that situation, that institutional fragmentation make it hard to have a comprehensive and adequate legal framework. Even though at the level of debt management office, the thing can be more clear in terms of overseeing day-to-day activity related to debt management. For example, negotiation, repayment, data publication, and reporting. So ideally, what is good to see is that the role and the responsibility of each institution to be clearly described in the relevant legislation. And the way is the authority is to delegate clearly a mandate and what should be done. We notice, however, that some countries do not conform to this practice and no formal delegation agreement is signed. This can lead to higher operational risk, especially when debt management is dispersed across different layers of government, and can lead to inefficiency and make development of a coherent debt management policy and the risk assessment more challenging. So these are the points I would like to wanted to make on the inadequate legal framework that we notice through our regional member country. Thank you.
Thank you, Mr. Mbila. Just to pick up on a couple of points that you made, I'm hearing that it's important that we focus more on best practices, in particular as they relate to legal and regulatory frameworks for borrowing. It's also important, you mentioned a particular example as well, but that countries abide by the rules that they've set for themselves as well, and that there is, in a corresponding way, kind of oversight to make sure that that's happening. So all your points are well noted. Thank you for your comments. I'm now going to pose the next question to Ms. Sibanda. So could you share with us some examples of how your country has worked to strengthen the legal and contractual frameworks for debt management, in particular taking into account some of the comments and criticisms, quite frankly, of that we've heard thus far today? Thank you.
Thank you very much, Nicole. Let me take this opportunity to thank the bank first before I make my presentation for organizing this very pertinent conversation. As Dr. was speaking, I was thinking he's taking the words right off my mouth. So as the government of Zimbabwe, we would like to believe that we've got a strong legal framework. Why do we say so? Previously, before the current Public Debt Management Act, we had a fragmented legislative environment as public debt management and administration lied or was governed by different pieces of legislation. So what we then did was to harmonize these pieces of legislation and also align them to international best practices. So what this has done is that we now have a public debt management instrument that is providing transparency and accountability within government. It not only does that, but it also creates various institutions. So there is an institutional framework that is provided for by the law, which sets out who does what within the debt management administrative value chain. So the key instrument there is the Zimbabwe Public Debt Management Office, which lies or is administered by the Minister of Finance. And this office has got various functions, but the key functions are that they are the principal advisor in the development of domestic capital markets and issuance of domestic and external securities on behalf of the government of Zimbabwe. They are also responsible for developing the medium-term debt strategy and also publishing the annual borrowing plan. So the debt office also does undertake an annual debt sustainability analysis on a yearly basis. And finally, they keep a database of all government's public debt. They are also the secretariat to a committee which is titled the External and Domestic Debt Management Committee. So the purpose of this committee, basically, which is chaired by the Secretary for Finance and comprises of the Attorney General and also the Governor of the Reserve Bank of Zimbabwe, is to recommend the maximum amount of new government borrowings and government guarantees for each financial year. So the Public Debt Management Office will implement the recommendations that would have been given by the External and Domestic Debt Management Committee, which is also responsible for making recommendations for approval of all external borrowings, domestic debt, issuance, and guarantees. But Parliament then plays a key role after these two institutions have made their recommendations, and which recommendations are then implemented by the Zimbabwe Public Debt Management Office. Parliament plays a key role because it is given the mandate by the supreme law of the land, which is the Constitution itself, to authorize borrowings above limits set in terms of the Public Debt Management Act, including limits on public debt and obligations guaranteed by the state. So Parliament also plays a key role in a ratification of any loans that the Minister of Finance would have taken. So the legislation is quite clear that borrowings are for a certain purpose and for a certain objective, and these are all laid out in the legislation. And it is only the Minister of Finance who is given the mandate to make those borrowings on behalf of the government of Zimbabwe. After those borrowings have been given for purposes of transparency, the Constitution mandates the Minister of Finance to gazette, which is a publication in the public fora of all the terms and conditions of any borrowings that would have been taken, whether it's a loan agreement or it's a guarantee. So the Minister of Finance is then expected to have those gazetted for public consumption. So the challenges that we are facing basically in the restructuring of our loans, as we are negotiating, because our debt as at December 2022 stands at 12.8 billion United States dollars, and 22% of that is penalties. So the challenges that we have been basically the primary challenge that we face as we renegotiate or reach out for restructuring of our loans is that the terms, most of the times, outside the standard. You would realize that they are so unbalanced to the extent that they are not aligned to international best practices. And some of these terms, the basic terms such as events of default, you will find that you are required to go further or have provisions that are wider such that they are outside the norm. And also one that we think we shouldn't be having problems with, whereby you are requested to waive sovereign sovereign immunity to an extent that government feels that it leaves government vulnerable. So, and also the pari passu clause. And we hadn't, I'm glad of the earlier presentation that spoke to climate resilient clauses, which we hadn't considered yet, but I think those are the clauses that we would want to consider going forward as we restructure our current debt instruments. As a country, we are expecting an El Nino this year, and recently in the past recent years, we had experience some floods. So I think if we have got clauses like that, that then allows the government to kind of breathe, would really appreciate to be able to structure our agreements that way. So what is the way forward? So government is currently carrying a lot of economic reforms, and we are indebted, and we'd like to extend our gratitude also to the Africa Legal Support Facility for the technical assistance that they've been rendering to us in various sectors, and also in the various plans that we are working on as government. But for public debt management, the key strategy that we put in place is the arrears clearance, debt relief, and restructuring strategy. So this is a roadmap that government has developed, which clearly outlines the next course of action going forward in terms of identifying low-hanging fruits as policy actions by government. So this strategy is hinged on a number of requirements, such as we need to renegotiate with the IMF so that we can be subjected to an IMF staff monitored program. We are happy to say that we have been engaging with them, and the responses that we're getting from them are positive. So we are hoping that in the near future we'll be able to sign off that staff monitored program. We have also identified that for us to be able to to be able to manage our debt effectively and to re-engage with the international community. So the minister has been re-engaging with the international community on a bit-by-bit process. So we also identified that as part of our strategy, we needed to conduct free, fair, and peaceful elections in this past August, and make sure that we put in place measures to combat corruption, and also draft legislation that will provide for transferable and bankable 99-year leases. So a huge chunk of our debt is what is owed to the former commercial farmers. So we are still in negotiations with them. And we did sign a global compensation deed, but we are still negotiating in terms of how that will be implemented. So also part of our areas clearance and restructuring strategy is the payment of compensation of former farm owners, basing on that global compensation deed that we have signed with them. And finally, we hope that we'll be able to have a targeted resolution of all our bilateral investment treaties. So because of the land reform process that we took, we found that we might or could have violated a number of bilateral investment treaties. So we are targeting resolving those as quickly and as efficiently as possible. So in brief, that is what we have been doing, and we hope that we'll be able to get technical assistance from the Africa Legal Support Facility regarding, I would say, primarily from the start, on if we could revise and review our debt management policy first, and after that, then be able to delve into the legal risk assessment in terms of all the debt that we have and the instruments that bind us, to say what are the legal risks, if we could get assistance also in that assessing that risk. And most importantly, I would think the renegotiation process. So that we make sure that a government is able to renegotiate for balanced provisions that allows government to be able to pay its debt and also keep its debt at a sustainable level. So that is my submission, Nicole. Thank you so much.
Thank you so much. No, thank you very much for sharing your experiences. And I wanted to, again, pick up on some of the things that you said, including the fact that you have been trying to address some of the challenges that were discussed earlier, in particular by harmonizing legislation and aligning legislation to best practices, including through, as you described, having the new public debt management function that provides for, and focuses on transparency and accountability. I also note your discussion on what Zimbabwe is working on now in terms of the strategy that addresses arrears, that addresses the relationship with former farmers, and also tries to address the issues that you're having with BITs. I did take notes on the things that you're looking for further support, so I look forward to being in touch after this call at some point. So our next question I'm going to pose to Professor Rodrigo Oliveres Caminal. So Rodrigo, there have been quite a few recent innovations in the sovereign debt restructuring world that have been aimed, as Laria talked about earlier, at kind of reducing the impact of potential creditor holdout action, such as, of course, collective action clauses and majority voting provisions. What do you view as kind of being best in class in terms of out of what's being offered generally or discussed generally? And are there better and more innovative ideas that African governments in particular should be thinking about? Thank you.
Thank you, Nicole. I would like to start by thanking the organizers for the invitation on such an important and topical webinar. In regards to your question as to contractual innovations or things that we can use in our borrowing agreements, be them loans or bonds, we need to depart from the fact or understand that since it's a contract, it's pretty much like a white canvas. You will face certain constraints because there are kind of standard clauses that you will come across in an international financial arrangement. But these clauses, what you need to bear in mind is that they can be negotiated and they can be tweaked to serve the purposes of the parties that are involved in the transaction. That can be either the borrower, either the debtor, or the lender, either the creditor. So this is where the issue of capacity building and building that depth of know-how, and also importantly is institutional memory, is to understand the purpose of each of the clauses. Even standard clauses like, you can name it, governing law and jurisdiction, can be tweaked, they can be amended to serve the purposes of the parties. So that's why it's very important first to understand that it is a contract, therefore it can be negotiated. As a result of that, every clause can be amended to serve the purpose, and that's why it's important to understand what's the purpose of the clause, what's the position of lender and borrower, also understand the strengths and the weaknesses, and based on that, tweak all clauses. So that's kind of the starting point. Going to your question about recent innovations, when we talk about recent innovation, there are different things that we can be talking about. I will start with some of the clauses that were mentioned at the outset. The most, I don't know if it's the most innovative, but the one that has become very common, widely spread, and including most of the financing arrangements nowadays are collective action clauses, which is like embedding within the four corners of the contract of a restructuring tool. As Nicole mentioned in the outset, there's no one overarching regime for sovereigns to restructure the debt. What I'm trying to say, there's no such thing as a bankruptcy law. For obvious reasons, sovereigns cannot go bankrupt, but therefore you lose those dynamics of majorities, minorities, and you have the problem of the holdout creditors. And that's why collective action clauses have come to the forefront to address that particular issue. These are clauses that need to be included beforehand to allow you to amend what were referred as the payment terms. And therefore, what you can do is you can extend maturity, you can reduce the quantum, you can reduce interest rates, etc. So this is one of the biggest recent innovations in sovereign financing, which is the inclusion of collective action clauses. If we go a little bit and try to dig into the history of these clauses, they were always present in UK law-governed debt instruments. But as of, I would say, the year 2003, they were also incorporated in New York law-governed instruments. Now they have become the state of the art, and almost inevitably all bonds will include CACs. And that's why in the earlier presentation, there was a reference to the fact that now syndicated loan agreements have also borrowed the use of collective action clauses from bonds, and now loan agreements will also include collective action clauses. Then what we need to look at is the reality is, what is the purpose that you're serving? What is that you are trying to achieve? Because there are other clauses that you can include in your documents to serve the purpose that you are trying to achieve. And again, we are focusing on contractual innovation, right? So these are tools that you can draft into your agreement. So on the one side, we have the plain vanilla, the standard clauses, and that touches upon what we were referring before as the pari passu clause, the negative pledge, etc. But then on the innovation front, what we can have is other clauses that can make it more appealing if you are facing difficulties to either accept the restructuring or to showcase to your creditors that you are not planning to default, and if you're going to default, they will be in a better position. This is very common, and this comes from instances where you have defaulted on your debt obligations, then you do a restructuring. So you need to convince your creditors, give me a haircut, give me breathing space, let me reduce interest rates. And the question the creditor will be asking you is, why would I bother? And then you're going to promise them, because I'm trying to do the right thing, and I will not like to be here again in 5-10 years. So that's why sometimes you can also include some provisions in your documents to showcase that you will not be there again in 5 or 10 years. And here what we are talking about are clauses like the right upon future offers. So if you do a new restructuring in better terms, you will be able to have access to those better terms. Or principal reinstatement, you did a restructuring now, I receive a haircut of, let's say, 50%. If you default again, that haircut will grow again. It will be like a haircut and a hair extension. It's basically the face value that has been reduced gets added to your new residual claim. Or as we have seen in the Caribbean region, they have been building what are known as the hurricane clauses. These are climate resilient clauses. And one of the best examples is Grenada. They were hit by a very severe hurricane, destroyed 70% of their source of income, mainly hotels, tourism industry and crops. They were launching and negotiating a restructuring with its creditors, and before they finalized the terms and they received votes from creditors, another hurricane hit the island. And that one they say, oops, we are prone to hurricanes. And that's how basically the region has evolved in incorporating now what are known as hurricane clauses. That means if you are hit by a hurricane, what you can do is you can obtain an interest holiday. That means if the hurricane is of a significant severity, that will allow you to trigger the clause, and that clause allows you to stop paying interest for up to, that's depending on how it has been negotiated in the contract, but probably up to 3 interest payments. So that means in bonds, you pay interest every 6 months. So basically, if you can miss 3 interest payments, that's up to 18 months. So that gives you an 18-month, a year and a half interest payment holiday. Interests are not foregone. They are added to principal and paying upon maturity. But what this allows you is prevent a default and in an orderly fashion be allowed to reallocate those payments to help you rebuild your economy. So I find this as a fascinating tool. I think this is very useful, but what I've been working, and I recently worked on a paper, is if we use this for hurricanes, why they cannot use for droughts or floods or any other phenomena. And then the question is whether, and this is the paper on which I worked on, is why we cannot extend this beyond an actual natural disaster and convert them into just because interest holidays. I mean, if there's an issue of severe magnitude, and we can claim if there's a pandemic, for which now they have developed pandemic clauses, but Rather than call it pandemic clauses or hurricane clauses, at some point we will end up with a list of 20 pages. If there's a hurricane, if there's a flood, if there's a drought, if there's a pandemic, if there's a war, rather than doing that, we can include just because. Of course, we have to have some caveats to prevent abuses, but to have the possibility that throughout the life of a debt obligation that matures in 20 to 40 years, for example, that you can take up to 18-month holiday because you have a bad economic cycle, because you had some mismanagement at the Ministry of Finance, or whatever reason. So it will have to come with certain caveats to protect this from abuses, but that's an option. Another one, if you want to be in line, and Nicole, I'm trying not to extend too much, but if another one could be, it's what is commonly used in corporate financing, which is to have a ratio. And these are called financial covenants. In order to guarantee to your creditors that the financial condition will not deteriorate, you will come up with a formula that will operate as an early warning signal that if you cross that line, your company might get into difficulties. And that's why you have this early warning signal that will tell you, if this happens, I am in breach of the contract. So you have to stay away from, between inverted commas, danger. So that's why in the sovereign context, I have seen at least one document where what they have included is a GDP-linked financial covenant. That means if your debt to GDP goes above X, which is the threshold, then it might become unsustainable. And therefore, if you because that, and how do you increase your debt to GDP ratio? By incurring more debt. So this prevents the sovereign from incurring more debt that will take it to unsustainable levels. But Nicole, just to conclude, what I can share with you if you want, but I don't think we have time, a couple of additional examples of clauses that are innovative, but the reality is that most of the conversation so far has been focusing on what to do when things don't go as planned. So mainly crisis management. I would like to highlight that that equally important, or in my view, probably more important, is prevention rather than cure. Because when we have to do a restructuring, we are already too late. So that's why I think, and if we focus on the restructuring, we get a more efficient tool to deal with the crisis, but we are not preventing the crisis. We are just putting off the fires, but fires can keep on coming. So that's why I think that an important aspect is for governments to focus on prevention rather than curing. And Nicole, back to you, and thank you very much for the opportunity.
Thank you, Rodrigo. We are definitely short on time, but I wanted to actually repeat where you started, which I think is a really important key takeaway, which is that borrowers really need to make sure that they understand the purpose of each clause in an agreement and be reminded that contracts can be negotiated and should be negotiated to ensure that they're fit for purpose. You mentioned a few other innovations that might help tighten up loan agreements for sovereign borrowers, including kind of adding clauses rather to agreements that make restructuring more accessible, and that also showcase that it's a one-off and there will not be another restructuring in the future. I like the idea of a just because clause, and I think it's also important for us to understand that while the international community and the world is talking about pandemic resilient clauses or CDRCs, that borrowers, again, do need to make sure that their loan agreements are fit for purpose and should respond to the concerns that they see might arise in the future for their countries, and not just take, climate or pandemic off the shelf and add it to their agreements. And the other point that you made was around GDP-linked covenants, which could be added to loan documents, again, to tighten up those agreements for borrowers. So thank you for that. I did promise and delivered, I think, on discussions around the legal and contractual framework that support and enhance effective debt management. We don't have too much time, but I will now ask 1 or 2 questions around restructuring. Dr. Masamba, can I ask you to talk about your experience, what some of the biggest challenges and complexities that you've seen in terms of ensuring timely debt restructurings on the continent? Thank you.
Yeah. Thank you so much, Nicole, for the invitation and the opportunity to participate in this event. And thank you for the fantastic question about what makes restructuring today more complex. And I think I'll answer this question in the African context. So to me, 4 things stand out. And of course, the presentation today provided the fantastic backgrounds to these challenges. You know, the fact that, again, we've been reminded that restructurings are challenging, especially during times of crisis, when countries need to redirect limited resources towards crisis management. And again, we've been reminded of the importance of international cooperation and even solidarity, if I may say so. So to me, the 4 factors that really stand out that make restructurings less timely and even more complex begin with the fact that coordination is challenging, especially coordinating the diverse creditors. I think this point has almost been made by the other speakers and in the main presentation. And not only that, but the fact that reaching consensus between the different classes of creditors is complex, whether it's official creditors such as multilateral and bilateral creditors, and your commercial and bond holders. And I think the most recent example of the complexity is Zambia's restructuring. So Zambia has, of course, reached an agreement, and it's taken 2.5 years. So between late 2020 and June 2023 to get in to arrive at an agreement with its official creditors. Now the question is participation or reach an agreement with private creditors. And interestingly enough, although the presentation did mention that many agreements today include collective action clauses, some don't. So for example, Zambia's 2022 and 2024 Eurobonds that form part of their 2027 series don't include collective action clauses. And perhaps Zambia is going to be another test case of how do we coordinate private creditors and whether we're going to see vulture fund litigation. I'm not sure. It's going to be interesting. The second point that I think delays restructurings or makes it more complex is the issue of the lack of transparency. And specifically, this relates to inadequate data and even inadequate reporting practices. And here I'm really speaking about the need for more transparency that relates to debt levels, repayment capacity, as well as the repayment terms themselves. I think I saw one question in the chat asking about debt management laws. Where do you find them? Questions might arise as to, are certain agreements in the public domain? And there's quite a number of examples of countries that have been advised to improve in debt transparency, such as I think Angola in 2018. That was one of the points mentioned in the IMF's report for the extended agreement under the IMF extended fund facility. The third point, I think, are the legal complexities. And I think these have been quite well expressed in the different responses by panelists and even in the main presentation. The complexities that arise in contracts, the complexities that arise in determining the rights of debtors and creditors, the complexities that relate to jurisdiction and even other legal questions. And one example I can provide is Mozambique's 2016 restructuring that related to secret debts that also resulted in legal disputes that had to answer the question on the validity and enforcement of these legal agreements, as well as that resulted in local disputes that tested the constitutionality of loan agreements that had not been approved by Parliament, and also international judgments by the UK courts, which was the jurisdiction of choice in these agreements. And I think the fourth point, I'm just keeping it short because of time. The fourth point I think that has been made quite clear are the capacity constraints. within the public sector, especially that relate to institutional capacity, as well as constraints with resources that can impede the negotiation and even implementation of restructurings. So to me, these 4 factors really stand out in the African context. Thank you.
Thank you so much for that. Apologies for not having enough time for you to speak longer. It was really interesting what you were saying. So if I could just briefly summarize what your key takeaways were. One is the challenges that are related to creditor coordination. Of course, we saw that, you know, kind of violently when it came to the Zambia debt restructuring. In particular. Also, you talked about lack of transparency, in particular as it relates to debt data and debt reporting. You talked about legal complexities related to sovereign debt. And again, Laria mentioned earlier the need for legal advisors to deal exactly with those complexities and to help governments navigate those complexities. And finally, related to the challenges related to capacity on the continent, within the public sector, including as they relate to resources and availability of resources. And of course, another plug here, which is that the ALSF does help with capacity building on the continent. So we're short on time. I had a whole nother set of questions. I understand that we're given a little bit more time, so those who can stick around, please do. I'm going to turn very quickly to the questions that were provided to us, so that we can answer some of your questions while you're still here. So the first question is whether the ALSF has a decision-making tool for countries wishing to borrow funds for their projects. For that question, Larry, if you're still in, are you happy to answer that? I'll take that one. I think the short answer, if I understand the question correctly, is yes, we do. I'm happy to direct you. Oh, you're there, Laria. Do you want to go? Happy to direct you to the ALSF's website for more information. But we have different processes that we have available to governments who seek ALSF assistance. Laria, were you trying to speak?
Trying to say the same thing. So,
okay, thank you. So the next question is whether there are any states in Africa that do not have dedicated debt management and monitoring departments, and if so, what alternative mechanisms are in place, and how effective are they in ensuring good debt governance? For that question, I think that's a tricky question for someone to know about all of them. But if I may actually ask you, Dr. Musamba, to make some comments on that particular question.
Yeah, that is a tricky question because it requires making an assessment of, I guess, the institutional structures of different countries. So I can't tell you off the top of my head if, you know, all African countries have debt management units, but I do think that it is important to have a dedicated unit that specifically deals with debt management. And I'll also borrow from Mr. Lumbila's presentation as well, where he mentioned that in addition to debt management units or departments, it's also important to have active participation of other institutions and departments that can provide I can say that can provide accountability and oversight functions. And these can include, for example, of course, participation of the Ministry of Finance, institutions like the Office of the Attorney General when it comes to contracting, as well, and the Parliament, as well as, you know, third parties such as maybe independent auditing bodies, and possibly even, you know, anti-corruption bodies. So although I'm not exactly answering the question, my response is I'm not sure, but I am saying that it is important to have that dedicated department and also work together with different institutions in and outside of the government institutional structure.
Thank you. Thank you for attempting to answer a difficult question. The next question I'm going to direct to Mr. Lumbila. There's a question on what the conditions are for acceptance and implications of restructuring sovereign debt at the African Development Bank.
That one is we need to be more precise. Is that involve the just the African Development Bank contract debt, or it's for other creditor? We need to be more precise, and I think the key thing is to, as Professor Rodrigo said, to remember that this is a contract. Who are the party to the contract, and usually in the contract you should have those terms in terms of when issue arise and how to arrange them. So that's what I can say right now, because this is very specific to each debt contract, I think. Thank you.
Sure. Thank you. Thank you for, again, trying to answer a very, very tricky question. So there's another question, and I think this is going to be the last one, unfortunately. I'm sure some of the panelists would be happy to answer questions offline as well. But there's been a question around strengthening accountability and enforcing rules related to debt management, again, more generally on the continent. I think for that question, I'm going to actually pass to you, Rodrigo. Again, I know it's a tricky one, but because I know that you've worked with several different countries and with the ALSF has worked on kind of the backdrop and the rules around debt management and accountability. That would be great if you could try to answer that question. Thank you.
Sure. Thank you, Nicole. It is tricky, but it's not an unsurmountable issue. And I think what we need to think is that has to do the issue of accountability. I think that for me is part of the prevention. And I think that on the prevention, this should build on 4 pillars. The first one is proper debt management. That means proper governance, mechanisms in place to incur the debt, Public Finance Acts, and clearly the limited responsibilities for and the involvement and interaction of different government bodies in the incurrence of the debt obligations. This links to issues about also what will be addressed, a well-trained debt management office, understanding the risks of the markets and how to hedge the positions of the government. The other issue, which is key to all what we've been discussed, and that has already been brought up, which is transparency. And all these 3 will kind of boil down into accountability and the rule of law. Because if we don't have proper governance, we need to make the government in office or the parties involved accountable. And for that, we use the rule of law. If we are not performing our duties in a debt management office, we need to have the debt management office accountable for that. So I think that all of this has to do, and it's directly linked with the issue about prevention. And Nicole, if I have just one more minute because there are a couple of things I would like to comment on the intervention of my colleagues in the previous round, which is, Magali, I just want to check offline. And Zambia 2022 and 2027, they do have collective action clauses. The other issue that I would like to comment is basically we were celebrating that Zambia reached an agreement under the common framework. And I think that after 2.5 years, reaching an agreement only with the official sector, and this is not a critique to Zambia, this is a critique to the platform that we have at the moment that is not flexible enough and cannot allow you to overcome difficulties over the shortest period of time to be able to re-access financing and start growing the economy again. So basically, we need to be, and again, here I'm wearing purely my academic hat, is we need to be more critical. We cannot wait 2 years to overcome a crisis, because what we are dealing with is people on the ground, and this can have dire costs for the economy and for a country as a whole.
Thank you, Rodrigo.
I wish it could have been a happier note to end, but
You tried.
it is.
So, okay, sorry to cut this short, but Dr. Limbila, Dr. Masamba, Professor Oliveres Caminal, and of course, Ms. Simbanda, thank you so much for all of your time and your comments. It was really interesting to hear from you in terms of your different perspectives on kind of the same issue, which is obviously complex and multifaceted. So thank you for your time and your contributions. Before we end for the day, we are going to get some closing remarks from Director Abdullahi. I have not presented yet, but he has extensive experience in development, economic governance, project management, operational policy, country dialogue, finance, audit, and advisory services. He has worked both in the public and private sectors. In addition to his current role, he has also served as officer in charge for the governance and public financial management department at the bank. Prior to joining the African Development Bank, he worked as a financial management specialist at the World Bank. And he was also, a supervisor and chief of mission at Ernst & Young. So, Mr. Abdullahi, the floor is yours for closing remarks. I will not come back. So again, thank you everyone for attending.
Nicole, I guess that Abdullahi is still at the board meeting.
Oh,
and
okay.
He asked me to say this word on his behalf.
Okay.
So, dear guests and panelists, on behalf of the African Development Bank and Director Abdullahi Coulibaly, I would like to thank you today's presenter and panelists for sharing your view, inspiring knowledge, experience, and ideas. With special thanks to the African Legal Support Facility for partnering with us, the Governance Department, on this webinar, and to the government of Japan for their continued support to our knowledge sharing work on sustainable debt management. I also would like to thank our bank colleague, including simultaneous translator, who made this event possible. This was a great learning opportunity for all of us, and believe that our audience agrees. Today's session highlighted the critical role of legal support for effective debt management and some of the critical challenges to addressing the growing risk of debt distress facing our continent. While debt restructuring for many countries is an imperative, we heard from Dr. Masamba how the issue of coordination among creditors, the global debt restructuring framework, information sharing challenge, and other political considerations remain significant hurdles. Professor Oliveras Rodrigo shared his perspective and reiterate the importance of ensuring the rule of law, improving transparency, and conducting substantive due diligence in debt contracting. I like personally the fact that they recall that debt is a contract with clause that can be amended to serve the purpose of each party involved. All of these aspects are considered critical to ensuring that all debt distressed countries reduce litigation risk, are able to ensure an orderly and proactive debt restructuring, and remain eligible for international financing. As highlighted by a colleague here from the government department, the bank is actively supporting African countries to strengthen their debt management capacity, and is currently implementing a 3-year action plan for the management and mitigation of debt distress in Africa. Providing opportunity for knowledge sharing and policy dialogue is one of the priorities of this action plan, And this webinar is one example of how we are implementing this. Lastly, I would like to thank Mrs. Sibanda for the debt management, from the Debt Management Office of Zimbabwe, for openness and shedding light on the challenge of debt restructuring in vulnerable and volatile setting. And also take the opportunity to congratulate Zimbabwe for its recent achievement, notably on the debt management legal framework. This will hopefully pave the way for other countries to step in their effort to improve the relation with creditor and enhance the country business climate. In closing, let me thank you all once again for your participation in this webinar. We are planning to have more webinars this year around the topic of debt management. Please stay tuned, and we look forward to you joining us again. Thank you. Hello, Nicole.
Hi, thank you for your closing remarks. I think this webinar has officially come to a close. So thanks everybody again.
Thank you.
But can you stay please 2 minutes for the digital picture, group picture for the end, please?
Okay, Mohamed.
CDT?
Oui, je suis là, je suis en train de faire la photo.
Okay. Can you switch on your camera, please, Miss Sibanda?
There you are.
Thank you.
D'accord.
Mr. Nomoto, can you switch on your camera, please, if you are still here?
C'est bon?
Ouais.
Tout le monde devrait avoir sa caméra ouverte.
Ouais, je pense que Monsieur Nomoto.
You have open camera, yeah.
Yeah, maybe he's not connected any
Yeah,
longer.
okay, no worries.
Yeah,
C'est
I
bon?
know
bon,
Olivier had to leave.
Je lance.
Ok.
Ouais.
Si tu dis que c'est bon.
C'est bon, Mohamed?
Sidiki, c'est
C'est
bon?
bon, la photo a été prise. C'est bon.
Okay,
Okay,
thank you very much.
merci.
Thank you.
Thank
all
you
for your
guys so much.
responses
Have a
this
good
day.
rest of your
Thank
day.
you. Bye-bye.
Bye.
Thank you.
Hi,
Bye.
thank you.
Bye-bye.
Bye.